How many advertisements?
There are 16 advertisements. Which we have challenged. Not total, but the petition is now 16 advertisements are here. All those who get 16 different districts, different persons. All your districts, so we can compare where it doesn't have names.
What about this 4/11/2003? 24/11/2003? Zio, the recruitment of more RET was stopped in schools, and the scheme would be used for filling of the post under the Sarv Shiksha Abhiyan. Where is this decision?
That's at page number, not on record. It's not on record.
So what is this? What is the relevance of this then?
Because how the entire system it ran, that's what they have made it. May not be otherwise. Actually, for the purpose of this case, nothing would be relevant beyond that. The scheme was there. Scheme has been abolished at that time. The selection list was published, and no engagement formally has been done.
Then for what purpose the petition was filed before the High Court, and what was the relief prayed?
Challenging the abolition of the scheme.
Abolition of the scheme was challenged.
Yes.
And what the High Court said?
High Court said that has protected, yes, upheld the scheme. The abolition has been upheld, but with certain observations. That is at page number, give the operative questions. Yes. Kindly turn to page number 73 of the convenience compilation. Volume 1.
73.
73.
Yes, please. Yes.
Para 31 at the bottom. We are so and so, so and so. Length of the impact of the government order on the pending litigation and well so and so. That the impugned government order will not affect the selected panels prepared by the respondent, which have been acted upon and formal orders of engagement have been issued. Where the formal engagement has been issued, that has been protected in terms of that abolition order. That the impugned government will not override the effect of the judgments passed or to be passed by this court holding a candidates entitled to engagement in the selection process, which was under challenge before this court. That is under challenge by the UT to the extent that in future also that will be protected only to the extent UT has filed. Otherwise, all petitions are by the private parties. Where the select panels are approved and the aggrieved party has approved the court before it could be acted upon, shall also be not affected by the impugned government order but for the litigation in the court, the approved panels could have been acted upon and formal letters of engagement prior to the issuance of the impugned government order. And notwithstanding anything issued so and so government order, the respondent shall abide by the judgment passed by the competent court of so and so. However, the writ petitions involving the adjudication of disputes list or tentative to so and so, that will have to be worked out separately. Any of the so and so discussions about so and so. Two and three.
Now you are challenging the direction number
2 and 3, which I pointed out in the previous order, which has been recorded.
Override
Yes.
or affect the judgment passed or to be passed.
Yes. Para 2, Roman 2 and 3.
So you are to this order will not override or affect the judgment passed. This part
or to be passed by this court.
Holding agreed by or to be passed.
To be passed.
Not passed is fine.
Passed is fine. At least to be passed.
Or to be passed by
passed.
this court.
What on you?
holding a candidate entitled to engagement of so and so.
Selection process.
Fine.
Hmm.
This is one.
Hmm.
The other is
Where the select panels are approved and the aggrieved party has approached the court before it could be acted upon, shall also not be affected by the impugned government order.
one by one. Where the select panels are approved.
Hmm.
And the aggrieved party has approached the court before it could
Acted
be
upon.
acted upon.
Shall also not be affected by the impugned government order.
Ah.
Acted upon means the engagement or the
Hmm. So what can be wrong in this? If
We are-
one is fine, then
the
impugned government will not be given a select panels.
yes,
So if one is fine,
yes.
then how this can be a challenge?
The second one is, suppose there is for some reason somebody had to file the writ petition challenging some selection process on various counts.
No,
You-
that is covered by 4.
Yes,
That is covered by 4.
4, 3,
We are dealing with 3 first.
3, correct. Three
Where
only.
the select panels are approved.
And the aggrieved party has approached the court before it could be acted upon, shall also not be affected.
It could be acted upon,
Yes.
shall not be affected.
Yes.
This will govern by correlation with 1.
No. One is the formal.
Impugned
Where-
government order will not affect the select panels prepared by the respondent.
One is select panels and for first one is formal engagement order will have to be issued. First one, Roman 1. In 3, even before the formal engagement order is issued, if somebody had filed a writ petition, that will protect them, notwithstanding the government order.
For clause 3,
Plus, how many writ petitions altogether? Told about 581 in Kashmir and 800 in Jammu. About jointly for 2 and 3, Roman 2 and 3.
what was the position in those cases?
They had filed a writ petition, they are pending, and many writ petitions are pending before the High Court. Engagement orders were not issued.
Pendency is not an issue.
Yes.
What was the stage of that selection? That is the issue.
The select list was published. However, no formal engagement orders were issued.
What is wrong in this, sir?
Once according to the policy, everything goes. Then there is no question of again bringing somebody. Everything goes.
Yes. You come to the policy of evolution.
Yes.
Page
Once
number-
policy is upheld by the High Court. Therefore,
Please, page number, policy, page number.
page number 62 is the policy. 76 is the
76 is the policy.
yes.
Finally, see 76.
Cancellation of withdrawal of the policy.
Page 76.
Yes.
The next page from impugned order. Yes.
Page number 76.
Uh,
Sanction is hereby accorded.
Alô, tem a votar. Bravo, dai, lo voto. Ik nopen. Ik nopen.